Okay. High impact land use claims. First off, how many of you have experience with land use? How many of you have angry neighbors who hate everything you do in your property because they have the right to their quiet enjoyment, right? I have a dog that loves to bark. Ripley, the one that was just mentioned, absolutely loves to bark. Favorite thing to do at 4, 5, 6 in the morning. Luckily, we live 200-300 feet away from our neighbors. Although it is problematic because when code enforcement's called to the city manager's house, it's a problem for the city manager. But one of the things, and as Brian mentioned, this is an area where I've really kind of cut my teeth in land use or in law. Some of you probably know my dad. I don't try and ride his coattails a lot, but Craig Call is my dad. So he's done land use for a long time. Before I went to law school and even when I was in college, I helped him run the seminars that he did. So I've been exposed to it for a long time. I've only been a practicing attorney for 10 years. But it's kind of where it's an area of law I enjoy. It's a very painful area of law. We've all been burned by it. Every city, every county, everybody I know has had a bad land use experience. And so we're going to talk about it a little bit, but I also hope that as we go through this, there'll be questions from the group and that you'll also be willing to share your experiences, because I really only have 13 slides. So that means if we don't spend 5 minutes on a slide, then we're going to have a longer break. I guess maybe that'd be good for everyone. But so please get involved because I think it'll help the conversation go much better. This is no particular order of land use risks. And because I turned these in early, I've even added some additional subcategories. But we've got federal rules, your general administrative decisions, your development agreements, legislative decisions, quasi-judicial, impact fees, city-sponsored projects. I also wrote down annexations and disconnections. Those of you who have been involved in those cases know how problematic they can be, and then conditional uses. And I think, does anyone have any questions about, is there one of these areas that you don't understand what I'm talking about? Or what we're talking about? I know it's hard to be like raising your hand and be like, John, I don't know. But I would say generally, a lot of these, there's basically the three main categories of decisions: your administrative decisions, your legislative decisions, and your quasi-judicial decisions. And everything else is a subset of one of those, but some of those are more expansive. The best example is development agreements is technically a legislative decision, but much more problematic than most legislative decisions if they're done incorrectly. I think the quote for legislative decisions from the Utah Supreme Court was, "We've never seen anyone lose a city lose a legislative decision case." Basically, if you're in that legislative decision area, you're safe. And that's why we kind of have this mentality from a city as we approach land use decisions. Should pop up. I call it's the DBS. It's what my parents taught me growing up. I might need to hit the next button. So don't be silly. My house was actually stupid, but I thought maybe for this group it would be different, right? One of the things my mom in particular beat into my head over and over and over again is think. Think before you act, think before you do things, because I was kind of a dumb kid and I would do things, hurt myself, hurt others, or destroy things growing up. So luckily I'm here and made it, 42 years old in a couple of weeks. So, but the other thing we can do is this S can be swapped out for other words. Don't be stubborn. Don't anchor on positions. My experience in land use on both sides of the counter. So as Brian mentioned, I've spent 6 years prior to my time with the city, or even I was an outside counsel for a while, but I worked for a lot of developers. I worked for Ivory Homes, I worked for Perry Homes, I worked for a lot of the people that sometimes seem to be the agitators for the government agencies. And I can tell you, almost every single time there was a land use case that ended up in court, it was because people anchored and took positions when they didn't have all the information. And I would say it's on both sides, you know, so pick Chris Gamboulis with Ivory Homes, taking an anchor position on something that he didn't have all the information. The flip side being a city mayor, city manager, attorney, someone who takes an anchor position on something that they don't have all the information. So I kind of use this silly as this phrase to be, you want to be flexible, you want to be mobile, you want to be agile, because if you're not, that's when you get burned. To put that into kind of my thought process is the best thing for those who are involved in land use decisions, the best thing they can do is to diffuse the strongest personalities in the room. And what I mean by that is, if you're in a room and there's one person talking and there's one person on each side talking, you're not going to reach a conclusion, because those people are going to agitate each other and they're going to anchor, and you won't reach a resolution. The other thing, and we'll hit on this again later, is when you get into these complicated situations, use the state property rights ombudsman's office. How many of you have talked to them before? So it's Jordan Collimore, Rick Plen, and can't remember the third one, but they are fantastic. Everyone in here represents a government organization, right? We don't have any of those dirty developers in the room. Is that right? I will tell you, statistically speaking, the ombudsman's office rules in favor of the cities more often than they rule against the cities. In fact, if a government's the one who's approached the ombudsman's office, they rule in favor of the government 72% of the time. And that's not to say that the government's always right, but when you end up in some of those where you're between a rock and a hard place, they're a good relief valve, a good pressure relief valve for both sides to go and talk to them. Landowners, when a landowner asks for an opinion from the ombudsman's office, they typically win 55% of the time. So not quite as high as cities do. Can you guess which group loses more often than they win? What'd you say? No, that's the landowners. Neighbors lose 66% of the time when they ask for an opinion. And usually it's because there's more of an emotion involved in their decision. That's why they're there. There's an emotional response. How dare my neighbor have cows next to me? Yes, I moved in 5 years ago and his family's been farming the ground for 100 years, but how dare they? Cows smell, right? And the other thing too is, and this is a hard thing for attorneys, at least from my training as a city attorney, when you get those notice of claims, what's the first thing you do when you get a notice of claim? Any call? I'm picking on you, sorry. Send it to travelers. I can tell you that most city attorneys, what we do is when we receive a notice of claim, we let the 60 days lapse. We do a little bit of investigation, but you don't typically respond unless you know there's a real reason, because how many of us get what we would call frivolous notice of claims? We get them all the time. And so I think when you're in the land use realm, you have to take it seriously. And the reason why is because developers, the legislature of Utah is a wholly owned subsidiary of the Home Builders Association. They are run by home builders, they are put in office by home builders, and they make rules that benefit home builders. And we've all seen that. The last couple of years has been rough. And so what we don't want to do is be the poster child. And we're going to talk about a few cases where people are the poster childs of some of these legislative changes, or some of these just lawsuits and the way they turned out. And so I hope we don't offend anyone. I hope no one was involved in these in a way that I'm going to offend them by talking about it. So if I do, I apologize. It is not my goal.
I have a question.
Yeah.
For the ombudsman, how binding is their opinion? Is it you can still appeal that or still sue the entity through through the judicial process, correct? Even though the ombudsman has ruled in favor of the municipality?
Yes. So no matter what the ombudsman says, the either party can still take it to court. And typically the ombudsman, hopefully the way it should work is the ombudsman's getting involved before it goes to the local appeal process. So the idea is there's some friction with the planning commission. The ombudsman gets involved. They provide an opinion that the appeal authority has, whether you have an appeal board or a hearing officer. And then it's often, most cities will toll the time while the ombudsman getting involved. They kind of put pause on that official process. Every city I know of, and it's not a lot, that end up going all the way into the lawsuit with the ombudsman opinion, it is not binding because you can't use the opinion as evidence in the actual proceeding. What you can use it for is calculating damages. So and last year they just strengthened the state code on this. And no one has tried it yet. But in theory, if the ombudsman's in your favor and it goes to an appeal by the other group and you end up prevailing, you have a better chance of getting damages. There's only one entity that's ever been awarded damages, and that was Providence City under that statute. And then my understanding, or my memory of that situation was it was part of the settlement agreement was to waive the attorney's fees that were tied into that. Because there again, as most of you know, as a government entity, your job and your goal is not to pound people in the ground. Your job and goal is to reach resolutions and make the city a better place. And most of us have better things to worry about than, some of the stuff that's happening. But so it's hard. So it's not controlling. It doesn't hold sway. You can agree to binding arbitration with the ombudsman's office, and then you would be bound by it. But most people do the mediation process or they get an advisory opinion. Any other questions about ombudsman's office? I do have a link to their website at the end. This is how I categorize the things that are the highest priority or the highest impact land use claims: development agreements, federal rules, impact fees, and administrative decisions. And the reason I put administrative decisions up there specifically is we run into all sorts of issues with administrative decisions as cities and as attorneys. How many of you have been in a planning commission meeting when the planning commissioners say, I know we have to approve this, but I'm not voting yes? And how angering is that? Because where you end up is in a lawsuit. And what do they use as evidence? The planning commissioners' comments during the meeting saying, hey, they knew they had to do it, but because their grandma stood up at the podium and told them not to, they said no. And we all dealt with public clamor. But that's one that's the easiest to control and the easiest to maintain if we have a good appeal process set up at our individual organizations. How many of you use a board of appeals for your organization? How many of you use a hearing officer? Okay, so it seems like the majority of people in the room use a hearing officer. 100% highly recommend it. And the reason why is it's a disinterested third party and it's not a group of neighbors. And I know that sounds like it's the exact same thing, but in general, and I would even argue, don't tell the Supreme Court I say this, I usually think one decision maker or a small group makes a better decision than a lot. And when you get a board of appeals, what you end up with is 5 to 7 neighbors who do this once a year and care more about the people in the audience saying children are going to die, you're going to destroy my home value, than anybody else. And so they get swayed by their neighbors. North Ogden City uses a hearing officer. We use Meg Ryan with the league. She's not an attorney, but she knows land use law, and she's fantastic at talking to the people who were there in the room and explaining the process and really walking them through it. And I can't think of a single hearing officer I've dealt with or worked with or seen in Utah who I think they shouldn't be a hearing officer. There are loads of good ones out there. So if you can convince your municipality, your district, whatever, to move to that, please do. That'll save you a ton of headache. So we probably won't spend a ton of time on federal rules. We will touch on it a little bit, but the reason is that federal rules, typically when you get burned quick, and it's over really quick. But I think we will talk a little bit and probably a lot about development agreements and a lot about impact fees. And then I added this extra thing, this disinterested third parties, and it's counter to what I just said about hearing officers. The same concept, but these disinterested third parties are those professionals that are outside of the city that you've hired who have very strong personalities. Be very, very scared of those people because they will cause problems for your organization. If they're the strongest voice in the room, then I would say they're outside of their lane, and the mayor, the city attorney, the city manager should be the one controlling the conversation, or a council member, whoever's in the room. Because when the disinterested third party, what their main goal, and this is just my limited experience, is to protect their professional reputation more than to protect the city or the county or whatever. So that's just a kind of an asterisk, and we might touch on that a little bit later. These are the cents, meaning it's not a big, we don't see a lot of claims in these areas because they're typically resolved very quickly. Legislative, like I mentioned earlier, there's so much protection. How many times, I mean, I can imagine, there's 10, 20 times a year someone calls the city and says they're going to sue North Ogden City because you rezoned property, and they say, hey, you're not going to win. Like, because it's pretty much the safe zone. The timing when you lose in legislative areas is when you say it's administrative. The only one who can help us walk that line is the court system. We all are aware of the Cottonwood Mall development. It was development agreement, there's a lot of stuff, but the real hinge point that flipped it into, hey, that a referendum was allowed was, it was a legislative decision as opposed to administrative decision. And they tried to push it through as an administrative decision. But there again, it's like, I'm trying to think of the quote, it's like offsides in soccer, right? I can't explain it, but we know it when we see it. It's the same thing the court tells us on that line between legislative and administrative. We know it when we see it, so we keep bringing those questions to us and we'll keep you in line. Quasi-judicial is pretty easy. Again, that ties back to the appeal board versus the hearing officer. City-sponsored projects. How many of you have been sued over a city-sponsored project or a county-sponsored project? Okay, one in the back, one kindred spirit. I have been sued over that. It was tied to a development agreement that was 20 years old. You might have seen it in the news, the North Ogden City Amphitheater is ruining neighbors' lives because we built an amphitheater next to houses. Well, I should say we replaced an amphitheater. Sorry, I'm a little snarky about that. But it's the thing that saved the city in this deal, though, was that we followed our own procedures. How many of you have built a building without getting a site plan or without getting your property rezoned? North Ogden has, which is why we did it for the amphitheater. Any others? I mean, this is in the sense category because you should be following your own rules. You know them best. And worst case scenario, what do you do if you didn't follow your rules or you can't follow your rules? I heard it over there.
Change the rule.
Change the rule. Your city council will change the rule, and now you can follow the new rule. So anyways, it's yeah.
Quick question from one of our remote viewers. They said with the change in the Governmental Immunity Act that now says cities shall respond within 60 days of the notice of claim, are most people now responding to a notice of claim instead of ignoring it?
Yes, I would say in our city, we haven't got a new one, a notice of claim since the rule changed, but the responses are still probably not what I think the legislature was after, if that makes sense. So Obviously, a thorough investigation with a lot of information is the best way to respond. The hard part is, as we all know, and it's a game that attorneys play sometimes, is the more you know, the more you can get penalized. And so I think providing an official response and telling them why you're denying it is important, but it's still, I'd probably say, in my opinion, probably still going to be half-hearted at best. That doesn't mean that's the best practice, but I'm just saying from a practical standpoint, I think that's where most cities lie, because how many, I know Paul and other city attorneys, we probably spend more time dealing with stuff that isn't really in the area of the law that we were trained to do. And I guess what I mean is doing things that other people could do. It's not just attorneys that can do it, as opposed to the regular. And so our time is short. Or with notice of claims, oftentimes they're handed off to a department head, the risk manager, somebody else, and they don't get as thoroughly investigated as we'd like. I do know that I have sent quick responses back to people. You get a notice of claim and 2 days later you respond back and say, no, here's why, government immunity. Stormwater, government immunity, King's Acts, we don't have to worry about it. So you think that answers their question? Okay. Here's my disclaimer. I'm an attorney. This is a picture my dad took in an elevator. And you can obviously see the problem. We cut off a little bit, but I just want to emphasize all of the thoughts I'm sharing with you today about specific cases are all in hindsight. I am 100% confident I would have made several of these same mistakes, just like many of us in this room would have. And I know I will get something wrong. A good example is what we just talked about. I made this absolute statement, attorneys don't respond to notice of claims. And we do, and we should, but we don't wholeheartedly respond to it, right? So please, if you have questions, concerns, or you want to challenge my authority, I'm 100% okay with that. And in fact, in a lot of these things we're going to talk about, or some of these case studies, I only know one side of it, or I only know what was in the newspaper. Yeah.
With Provo City, with that change in the statute, we've taken the tack where we send out just an acknowledgement letter that the paralegal prepares with every claim. Just saying, we got your claim, so that if they ever say you didn't comply with the statute, we can say, sure we did. Send you a letter saying you got it.
And that's really great. And that's the whole reason why we need to encourage this process. We haven't thought of that. Sending out a response saying, we acknowledge we got your claim. You probably know that claims have been lost because they send it to the mayor instead of the city recorder, and it's the city recorder that's on the state statute. So sometimes if you get claims that aren't sent to the right spot, how does Provo deal with those? Like if they send it to the mayor instead of the appropriate spot?
Well, we're kind of weird on that. We have an ordinance that actually gives a broader permission, or they can file with the attorney or the mayor or the city recorder.
Okay.
But pretty much all funneled to the city attorney's office. Since we do all our things in-house, we're just kind of set up to do that. But I think another advantage, our letter also says, if you didn't give us, an estimate, if you didn't give us a figure, we're not going to respond. Not exactly. Well, I should say, if anybody would like to see what we send out, we'd be happy to talk about that.
That's really helpful. And for those who maybe didn't hear that, essentially what Provo said is they have their own rules internally that govern these notice of claims, and they have a form letter that is modified and sent to everyone so that everyone's getting a similar response with that initial communication or contact. Okay. So let's talk about our first one, and it may be our last one. We want to talk about development agreements the whole time. It's your time, not mine. So we can do that. But this is probably one of the most famous development agreement cases in Utah. Tooele Associates versus Tooele City. This was all about water, and specifically about water in the desert. And I don't want to focus on the specific language the court said. I want to focus on the language that got him in the lawsuit, and then what that resulted in. So my quick summary, and again, I know a little bit about it, not everything, so if someone knows more, correct me. Essentially, the city and the city's water district promised a 2,761 acre development. They would be able to provide them water. And the problem with that was they didn't own the water yet. And that's what this whole case is about, in my opinion. Because everything that happened after that decision happened because water doubled, tripled, and just went through the roof in price, which makes sense because how many of you own water rights? You actually personally have water rights. As soon as a development comes in, water rights always go up. My parents live in Plain City. 20 years ago, you could buy a share for $200 for an acre. I think right now the going rate's $4,500. And the similar thing, not exact percentage, happened in Tooele. And I would argue, again, with my limited knowledge, that it largely happened because of this development. That because people knew now water was going to be more scarce because we're providing water for 8,000 homes, that water became more valuable. And that's what got Tooele in the pickle they were in. And then instead of resolving the situation early, it escalated. So this ties into the construction of the development agreement. Best practice, in my opinion, is you never promise something you don't already own or you don't have absolute control over. A good example is the city has absolute control over its land use code. We can promise just about anything we want as far as zoning changes because we can deliver that. The hard part is you can't bind a future council. So I know I might be skipping around a little bit, but in theory, if you're promising a land use change, you have to make the change at the time you make the promise. You can't promise to do it in the future because the next council might say, well, we don't have to do a land use change, and the courts will agree with them. And that also might bring in damages. But essentially, don't promise something you don't own. I will say, those of you, so the claim, the way this came out, it actually went to appeal court twice, if I remember, back and forth over damages, over different nuances. The original notice of claim, I think, was for $220 million, was the original, hey, this is how much we're going to sue you for. It ended up obviously getting reduced and scaled back. The judgment in favor of Tooele Associates was $22.5 million with a $1.8 million damages offset, meaning that Tooele Associates they had done some damages to the city and that offset, but still a $20+ million lawsuit was litigated, which sounds like a bunch of money. I will tell you there were two victorious parties, maybe three, in this lawsuit. One was the developer. The second one was the developer's attorney. And the third one was the city's attorney. According to TooeleOnline.com, which I believe is a local group, the city spent $5 million in attorney's fees fighting that lawsuit, which is a lot of money, right? That's Bruce Baird was on the developer side, and I think he had an issue with Ogden once. It might have been back when he was still consulting for cities at the time. But there was a lawsuit over the development that is now the Junction, where the old mall used to be. And he in these communications with the opposing counsel said, listen, why don't we both just buy Dodge Vipers and agree on what it should be, because that's where we're going to be anyways. And that's basically what happened. The people who make the money are the attorneys. And nothing against attorneys as a profession. It's a noble profession, but they're hungry and they have to pay for their time and efforts. And the really good attorneys are going to give you the most protection or give you the most advantage or very expensive. And there's not a lot of attorneys out there who are bleeding hearts. Although there are some good ones. Most of them work for nonprofits or cities, right? Right, Paul? But so just really, really be careful. The other thing that I've learned in my time with North Ogden City is If it's a promise in a council meeting, make sure it makes its way into the development agreement. We're all learning, we're all growing. We have a development in North Ogden called the Village of Providence Point, 30 acres, 600 homes. In the council meetings, the developer got up and said, I will do this, I will do this, I will do this. And then it never got put in the development agreement. And so we're still living on a promise. And it hasn't turned out well for the city, or really it hasn't turned out well for the residents who bought into that facility because they're unsatisfied with how quick it's going, and they don't have the clubhouse, for example, yet. So there's about 100 townhomes with no clubhouse. And we're still being promised it'll be the next thing built. The trouble is we tied the promise for the clubhouse to the apartments, not to anything. And so what we ended up with is we all assumed apartments would go first because that's the easiest thing to build right now. How many of you are just denying apartments left and right because everybody wants them? I mean, everybody. The flip side is they're also one of the hardest things to capitalize. You know, that when the investors are looking in it, if you've imposed aesthetic standards, they can be very hard, where residents and homeowners are so agile that the for sale townhome units in North Ogden City, the market was able to respond really quickly, and we were able to get those units sold, and they don't have a clubhouse yet. I've been promised the building permit showing up on my desk this month, but you know, like I said, write down your promises. And this kind of goes around on some of it. Know how much it's going to cost you up front. That's what we talked about with the water. The wiggle room. The reason that North Ogden City won the lawsuit against the amphitheater discussion, or why we prevailed in that case, was that there was a provision in the development agreement, the original sales agreement for the property, that said the city can respond to changes in time. And basically that was enough of the language for the court in the initial injunction hearing to say, hey, the city has all the wiggle room. That everybody agreed at the outset of this, that things are going to change, stuff's going to move. And even if they didn't contemplate it in the original agreement, though the city's position was that we did contemplate these type of things in the original agreement, they have the power now because that wiggle room language gives you so much room. We already talked about only promise what you already have. I would put personally binding arbitration in all of my development agreements. And the reason why is it's the same thing. You can spend $100,000 with the best land use attorney in the state, although Jody Burnett's retired, but he was one of the best ones for the cities, obviously, in an arbitration. And if it's in a court setting, it's 5 or 10 times that easy, because the paperwork that a court requires as opposed to an arbitrator requires is significantly different. And most of the arbitrators that I've had the best experience with are retired judges. So they get it, they understand the process, and they continue doing what they're doing because the ones I've dealt with, they like it more because it's more about reaching a resolution that works as opposed to applying the law. So I would put arbitration clauses in all of my agreements. But your city council might not like that because it does basically put everything in the hands of one person that you may not know, although there is the option to do with like a 3-panel of arbitrators. Anyone disagree with that? Any of these approaches on development agreements? Hey, you're making me feel like I'm boring you to death, but maybe not. Assisted living centers. We all have them. We all have group homes. And how many of our neighbors, our residents want these in our city? 0. I see a lot of zeros. I see 3 zeros. Assisted living centers are not typically as bad as group homes. And particularly when you start getting into the range of group homes that are dealing with some of the abuse, drug abuse, alcohol abuse, things like that. The trouble is, in these federally regulated areas, the penalties are mandated by federal statute, and almost always, without exception, include attorney's fees covered. If you prevail, you get your attorney's fees. It's not the court can award them, it's you get them. The Far West had an assisted living center proposed. one of those situations where the planning commission says, we know we have to approve this, but I can't because my neighbor's looking at me, so I can't say yes to it. Jody Burnett came in on the city side after they had approved and had gone through the appeal process, and his instructions to the city were, it's approved and pay the $80,000 of attorney's fees that the developer has spent. And, you know, the city obviously paid Jody as well, but that's what, it's kind of that anchoring and kind of that trouble. If they would have had a third party board of appeals that was or a hearing officer, I imagine they would not have ended in the same issue, because my impression is that, and this was not my case, but I know the attorney quite well, that the plaintiff they weren't after the attorney's fees. It was more important to them to get started on the building than to not. Interestingly enough, I believe it's a 20,000 square foot facility, single level, 20 beds, 25 beds, if I remember right. Most of the homes in the neighborhood are 8 to 10,000 square foot homes, very large homes. And it actually blends right in. Just looks like another mansion, because they hid the parking really well. They did a lot of stuff. Driving by, you'd hardly know it was there unless it's outside your front door. The other one that seems to come up with federal regulated areas, cell towers. You know, that's not as big of an issue as it used to be, but it can be problematic. Any thoughts about cell towers? I haven't had a ton of experience in that area, to be honest. So any advice from the group? Okay. The group homes, again, the smaller version of the assisted living center. This is a comment that happened in North Ogden. This is a single family neighborhood. That's what people always say, right? The home was for 4 to 6 individuals with mild autism, so very low on the spectrum, who were transitioning into adult life. The whole purpose of this group was to take young females and help them learn how to become adults and be that space between living with their parents and living on their own. The person who was the loudest and the most upset about it got up and said this is a single family neighborhood. We didn't buy here to have this type of facility across the street from us. Then his brother got up and said the same thing. And then both their wives got up and said the same thing. And they actually had their kids with them. And they all lived in the same house. So if I remember right, there was 10 people living in the house across the street complaining that this is a single family neighborhood. And all the stuff that's coming with ADUs and things, I think we all kind of anticipate we're getting those nuclear families happening and things like that. So it's not unusual for brothers to share houses with their families and things like that. But it's the perception of what's the impact on the neighborhood and how dare you. Luckily, my planning director at the time and the developer or the owner of the project were able to assuage, or that's the right word. I sometimes use too big of words. I should just dumb it down for myself. They were able to mellow out the neighbors and work through so many of the issues that it turned into we promise we'll never have more than 2 trucks there, because none of our residents drive. So we'll have 2 for each employee. And so a lot of the things were able to go away and everyone parted as friends. And conversely, a couple of years after the fact, the neighbors are very happy for the facility. It's very quiet, very well managed. Haven't heard any complaints. And in fact, I've heard some praises. The impact fees. How many of you charge impact fees? How many of you have had a developer come in and say, I'm going to sue you over impact fees? Happens all the time. It's what I used to do. That was the majority of my practice when I was in the private practice realm, was impact fee law. And most of the time, what the developer really wants is what we talked about earlier, is for everyone to hit pause so we can talk about it. There's a case study in Utah where the Home Builders Association approached an entity charging an impact fee and said, it's $600 too high. And the entity said, no, we're fine. Trust us, we're fine. And I would argue the third party, disinterested third party said, no, trust me, it's fine, because their reputation was riding on it. Had the case been settled at that point, or the argument, I believe there was about 500 to 1,000 impact fees that had been paid. So it's not nothing. I mean, it's $300,000 to $600,000. But because people dug in their heels and because it drug on, it ended up resulting in over a $30 million settlement. And part of that's because there were so many impact fees being generated, and all that does, in my opinion, is gives the plaintiff's attorneys and their experts time to chip away at the impact fee statutes. And at the same time, this case was going on, I was involved in one with Pleasant Grove, where a developer, an HBA, same thing, an HBA went to the city and said, hey, you're charging too much. And the city attorney said, let's just pause. Let's all agree that we're drawing a line in the sand and say any impact fee paid after this point, we understand is part of this challenge. Let's go through the process. We're rewriting our impact fees. Let's talk about it. That resulted, I think, in about $100 to $150 refund to the home builders, but they were happy because the city hit pause. I mean, I would probably imagine I'd bill them $2,000 or $3,000 to the home builders for the time I spent on it. And the city, everyone ended up in a better situation. And it was all because the person in the room, I can't forget the attorney's name. Is it right? Who's Pleasant Grove attorney? He's an outside office. Yeah, so Tina's office. They came in the room and they said, okay, city, let's pause. Let's talk. We can all be friends. And they ended up, basically, I think it was a win for everyone. It was a healthy process for the HBA and the city. And it resulted in now an impact fee portfolio that the home builders weren't going to challenge because they were involved in the process. So that might be the other comment that I didn't think about is if you have a very active HBA in your area, involve them in the impact fee process from the get-go, because if they have buy-in, they're less likely to challenge. I can also tell you that there are cities or there are developers who have wanted to sue cities over impact fees and they don't, even though everyone agrees it was wrong, at least on the plaintiff side, because the relationship is more important to them than the money from the impact fees. And as we all know, the people who pay for the impact fees aren't even at the table because a home's going to sell for $400,000, whether the impact fee is $1,000 or $2,000. It's just what a home sells for, and basically the future landowner is the one who eats the cost. Let's see. This again, this is that disinterested third parties, and I'll kind of talk about. Am I over? Just barely over? I'm okay. Anyway, this is my last slide that I really want to hit on because we already talked about the ombudsman, which is my real last slide. The people, when I'm talking about disinterested third parties, I'm talking about attorneys, engineers, and sometimes council members or mayors, because what you end up with is someone who's there for the wrong reasons. And that's a recipe for disaster, in my opinion. So with that, any quick questions? Sorry, I thought I would be way short on time, and here I am just gabbing on. I was even going to tell you a dad joke, and I can't now. Any questions before we close? If not, you can find me. I'll be here for a good portion of the day. I do have to sneak out before the last presentation, but you can grab me. Okay, I'll tell you my dad joke. How heavy is a rainbow? It's pretty light. Sorry, most dad jokes are across the line, so thank you.